I'm Dr. Reese. I'm an associate professor of finance and economics in the School of, oh, I should stop moving around, in the School of Business and Public Management. And amongst other things, I am interested in how capital markets work. I'm very much interested in how capital markets work. And I'm also interested in what people refer to as socially responsible investing or multiple objective investing. And as part of my interest in that, I've been very curious to observe some trends in shareholder advocacy in the wake of the Great Recession. So that's what we're going to have a brief little chat about today. So, quick overview. So in the wake of the Great Recession, we've seen an increase in shareholder advocacy. And when we talk about shareholder advocacy, we're talking about things that shareholders attempt to do to encourage management and the board of firms to operate in certain ways, make certain strategic decisions, avoid doing certain things, etc. So in general, we've seen an increase in shareholder advocacy in the wake of the recession. And in two, we've seen some particular increase or significant increase in shareholder advocacy with respect to the issue of executive compensation. And so there's been a real spike in shareholder proposals related to the issue of shareholder compensation. Executive compensation. So there's been a real spike in the activity and proposals around various schemes associated with executive compensation. Now, when we talk about shareholder advocacy, we're talking about those sort of actions that shareholders take to try to influence, how corporations operate, where they operate, who they employ, what sort of products they provide, and also how they even act in the political arena, because in the wake of the recent Supreme Court decision a few years ago, now corporations are actors, are very much actors in the political environment, and that is, of course, of concern to some people and a source of celebration for others. All right. Now, shareholders don't run companies. Now, we should be clear about that. Management runs companies, and boards are responsible for supervising management. That said, shareholders do have ways in which they can want dialogue with firms, dialogue with management, dialogue with boards, and try to encourage boards to operate in one way or another. All right, now, shareholder advocacy is just one of two basic strategies employed by investors, institutional investors, and money managers who are interested in the world of socially responsible investing, or the field of socially responsible investing, or in what I would like to refer to as multiple objective investing. And just a quick overview about what's going on in that field. In the last 20 years, we've seen a tremendous growth in the field of socially responsible investing. We've just seen a plethora of funds develop, and we've seen more and more institutional investors and money managers move into that space. Now, shareholder advocacy, as I said, is one of the tools or strategies that people use in this arena. And just a quick overview of SRI, and then we can move on to the topic of interest today. Here's a chart that sort of summarizes kind of what's happened in the field of socially responsible investing, multiple objective investing, from 2007 to 2014. And you can see that there's been a threefold increase in the assets under management that are screened for either environmental, social, or governance related issues. You also can see that there's been a more than doubling of the institutional investors who hold funds that are engaged in some sort of shareholder resolutions. In other words, they're making proposals to management in some way trying to influence how the firm is being operated, how the firm is governed, what sort of products the firm is producing, how it's dealing with its personnel. And so again, there's been a tremendous amount of activity in the field in general. Now, let's just quickly talk about shareholder advocacy and the tools available to shareholders to try to influence management. First and primary is just proxy voting. Every shareholder is entitled to a vote for each share they hold on issues that come before an annual meeting of a publicly traded firm. All publicly traded firms are required to have at least one annual meeting. They gotta have an annual meeting. It's gotta be public. It's gotta be announced where it's going to be. And well in advance of that meeting, they have to essentially send out an agenda of items that are going to be considered at that meeting. As a practice of sort of common sense, most shareholders don't make it in person to the annual meeting. So when firms send out this agenda of issues to be considered, they also send a quote-unquote proxy statement. And that proxy statement is best thought of as kind of an absentee ballot. In the same way we use absentee ballots in the political process, a proxy statement is really an absentee ballot, for corporate business. And it gives shareholders who do not attend the meeting the opportunity to instruct management as to how they would like to vote on various issues if they do not attend. Now, second way in which shareholders can influence management and boards of directors is through filing shareholder resolutions. And again, this is, a shareholder can craft a proposal regarding some issue in terms of how the firm operates or how the firm is governed or what sort of products the firm is involved in or how they're dealing with personnel, and submit that for consideration. They can submit that for consideration. And if it meets certain criteria, then it can be brought to the annual meeting for a vote by all of the shareholders. And of course, the third method by which shareholders can influence management and board of directors is just through dialogue. The Supreme Court has recently made it very clear that money is speech. And then in this arena, money has always been speech. If you're an investor, you hold a significant position, or you represent a significant sum of funds to be invested, then generally you can get an audience with management and or the board of a firm to talk about things that may be of concern to you. And it doesn't, that doesn't guarantee that management or the board is going to go along with whatever it is that you have in mind, but you can certainly get an audience. You can get an audience. So let me just talk a little bit more about this proxy voting. And again, in contrast to sort of the political arena, where it's one person, one vote, in the capital markets, it's one share, one vote. So, he who has the most shares, carries the day. Now, again, the best way to think of this proxy is it's really just an absentee ballot. All right? So it's the equivalent of absentee ballot in a political election. And now, again, shareholders do not have to go to meetings to weigh in on issues. They just submit their proxies. They don't have to go to the meeting. They don't have to be there to weigh in. So, and frequently it's not convenient for people to go to meetings, because shareholders typically are all over the country, and frequently you may have international holding of your shares, and so it may be prohibited for people to travel to the annual meeting. But that's not necessary. And also I should note that while in the old days most proxy voting was by mail, increasingly firms are moving toward electronic proxy voting, which is essentially you get a code, and then you can go onto a website and you can vote the issues. All right. Now, of course, one of the concerns with this electronic method is that in the old days when people used paper, there was paper to, sort of go back. There was an artifact of the voting that could be audited. And now, of course, with this electronic voting, that requires people to come up with some new regimes to figure out how to archive those records. Now, filing shareholder resolutions. Filing shareholder resolutions. Who can do this? Now, who can submit a resolution? There are some requirements. You can't just buy one share and be like, hey, you'd be a gadfly and say, hey, I'm here to introduce resolutions, and sort of tie up the business of the firm. So there are some requirements. Having said that, the SEC, the Securities Exchange Commission, which sort of sets the rules for publicly traded firms, has made these requirements relatively benign. They're not difficult requirements to meet. If you own at least $2,000 or 1% of the shares of the firm, whatever is lower. So either $2,000 or 1% of the shares of the firm, then you can submit a resolution, assuming you've held those shares continuously during the past year before you want to submit that resolution. So you can't just show up like 2 weeks before the annual meeting and say, well, I'm going to buy some shares and I want to submit a proposal. And you have to have been a shareholder of record for at least the past year prior to submitting a proposal. All right. Now, as you can imagine, because people are busy, and for those of y'all who have holdings in mutual funds in your 401k or 403b, I'm not going to ask anyone to tell on themselves, but I am going to get you to just think about this. I'm sure proxy statements have come in the mail, and I'm sure that they're on the top of the pile of things that you want to read before you get to watching the latest episode of Games of Thrones. And now, having said that, there are people unlike you all who sometimes either one, ignore the proxy statements that come in, or two, don't read them with a lot of attention. And so it's not unusual for a shareholder proposal, particularly if it's one that's not being promoted by management or the board, not to get a lot of traction, certainly the first time out. So again, frequently people make investors will introduce a shareholder proposal for a vote. But again, unless they've got a lot of money to really sort of get the attention of the investing public, it's not unusual that the first time out that proposal may not gain a lot of traction. So the SEC has established some sort of rules in the light of that fact. And you can refile proposals. So if your proposal doesn't pass the first time, you can refile a resolution. And if you can meet some conditions, if the first go around, the first year, the first annual meeting where you introduced a proposal, you get at least 3%, you have the opportunity to reintroduce that item the following year. Now, the following year, the hurdle goes up a little bit. You got to at least get 6% of the shareholders to vote in favor of your proposal if you want to bring it back for a third year. If you want to bring it back for a third year, you've got to get at least 10%. You got to get at least 10% of the shares that are voted to vote in favor of your proposal to bring it back for a fourth or any subsequent years. So again, but this rule is a recognition that in a world where people are busy and lots of people, hold shares, again, through their 401k, 403b, so they haven't necessarily selected this investment themselves, that they have limited time to do the due diligence associated with being a shareholder. And so again, a lot of times shareholders don't give a lot of attention, at least initially, to some of these shareholder proposals. So this is a recognition on the part of the SEC to help firms get help investors who introduce these proposals to get some traction and to educate their fellow shareholders about an issue before management is able to sort of table that issue, or the board is able to table that issue. All right, now, and last but not least, again, there's this issue of dialogue, and that shouldn't be given short shrift. If CalPERS, which is one of the large pension funds in California, goes to Walmart and says, guess what, we're really concerned that 25%, 30% of your employees, your new employees, are eligible for food stamps. Maybe you should think about, your compensation policy. Well, guess what? They get a hearing. They get a hearing. And so the point is that when significant institutional investors and our money managers, bring an issue to, to management's attention or to the board's attention, that gets on management's radar screen. That gets on the board's radar screen. And again, it doesn't necessarily guarantee an outcome, but it certainly puts the issue in play. All right. Now, let's look at what's happened with shareholder resolutions. Now, before the Great Recession, looking at just sort of two snapshots, 1997, 2007, you can see that resolutions were filed by institutional investors and money managers that represented about $720 billion in 97, and a similar amount in 2007. So we won't see a lot of change there in this 10-year period. There are people who are running significant sums of money who are concerned about some issues, but you don't see a lot of growth in that population of money managers and institutional investors. All right, so no meaningful change. But let's jump ahead to after the recession and see what happens. After the Great Recession, I should say. All right, so now we go to the Great Recession, and you can see that, boom, we go from $720 billion to $1.72 trillion. So now, in the wake of the Great Recession, we see institutional investors and money managers who represent $1.72 trillion filing resolutions, trying to influence how various publicly traded firms are operating in the marketplace. So clearly we're seeing a huge increase in this activity and a huge increase in the number of institutional investors and money managers who are using this as a vehicle to influence corporate behavior. Now, again, I just want to compare these side by side so you can sort of see how dramatic this difference is. Clearly something happened between 2007 and 2014, and to change people's behavior. Something happened. All right. Now, particularly what we saw is a huge increase in proposals around governance, but particularly around executive compensation. We see a huge increase. And I just want you to look at this. Now here are numbers of proposals that are submitted to publicly traded firms in 2012, 2013, 2014 regarding various governance issues. And you can see we have, I guess it doesn't work. You can see, board diversity issues. Do you have people of color on your board? Do you have women on your board? Do you have, any people from organized labor on your board, et cetera? Then there are issues of board declassification. Most boards are set up where not all of the directors come up for re-election at the same time. They're set up in quote unquote classes or tranches. And the idea there is to maintain institutional memory, but what it also means is it's very difficult to sort of influence the direction in the board stewardship when the vast majority of the board doesn't turn over. And it may take more than a decade for the whole board to turn over. So if you're trying to get traction on the issue, this is a problem. A lot of firms have governance rules that don't require that board members get a majority of the shareholders vote to actually prevail in an election. So there are people who are concerned about that because they feel maybe it might be helpful to have directors serve only if they can get a majority of the shareholders to vote for them affirmatively. This issue of independent board chairs, this relates to whether or not you have a situation like a Jack Welch type situation where you have the CEO is the chairman of the board of your corporation. Now, technically, the board supervises management, which means the CEO reports to the board of directors. But how exactly does that work if you're the CEO and you're the chair of the board? I guess you're your own boss. So there are people who are really, there are whole sets of investors who are just very concerned with a governance structure that allows, the CEO to be the chair of the board, because what you can often do is create an echo chamber. Because think about it. If I'm on the board and I'm, say, the senior vice president of finance and I sit on the board, and let's say that Ms. Fuller is the CEO, but she's also the chair of the board, well, when Ms. Fuller has some idea that is not really financially that feasible, initially I outlined for her and the other members of the board some of the concerns I have about this proposal. But when CEO Fuller says to me, I hear you, but I think there's a lot of synergy associated with doing this particular project, she says that about 2 or 3 times, then I have to make a decision as a senior vice president of finance and board member. And that decision is, do I want to get my resume together, or do I just want to go along with the program? And so this is one of the reasons why people think it's a good idea that the board chair not be part of management. Now, the issue I was concerned about is this issue of executive pay, because you see a huge spike in activity in this issue. And if you look at these 5 categories, in all 3 years, executive pay represents the largest percentage of the proposals in all 3 years. And in fact, let's just look at this on a percentage basis. In 2012, 31% of all these proposals concerned with governance were about executive pay. In 2013, 42% of the proposals on governance were about executive pay. And again, in 2014, almost 40% of the proposals submitted are about executive pay. Clearly, institutional investors and money managers are really concerned about this executive pay issue. Why? Why are they so concerned about this? Now, it could be situations like this. For those of y'all, let's just go back in our Wayback Machine. March 14, 2009. It's hard to get people outraged in New York, DC, and the rest of the country all at the same time. But the New York Times featured a story that produced almost universal outrage around the country. And on the business section, the headline read, AIG planning huge bonuses after a $170 billion bailout. For those of y'all who don't remember, AIG was this big insurance company that was in this business of selling, amongst other things, credit default swaps, which is a way of making investors in mortgage-backed securities whole in the event the underlying mortgages that supported those bonds didn't perform. And of course, in 2007 and 2008, a lot of those underlying mortgages did not perform. And the bonds, as a result, defaulted. And so those bondholders came to AIG, people like Goldman, Sachs, and pension funds all around the world, and said, guess what? We would like to collect on our credit default swap. And eventually they ran out of money. But because we didn't want all the firms that were owed money by AIG to go out of business, then the federal government infused ultimately $170 billion into AIG, which then flowed to those other firms that were due payments. Now, story continues, and I'm going to do something I never tell students to do. I tell students never do this in a presentation, but in this case, I'm actually going to do this. I'm going to read this because there's no more efficient description of this than was provided by Andrews in the Times. AIG, which received more than $170 billion in taxpayer bailout money from the Treasury and the Federal Reserve, plans to pay $165 million in bonuses by Sunday to executives in the same business unit, not just in the firm, but in the same business unit that brought the company to the brink of collapse. In other words, the same unit that sold all these credit default swaps that many people feel contributed mightily to the financial crisis and subsequently to kicking off the Great Recession. So this could be a reason why people are concerned about executive pay. I don't know. And then there's this other issue about what's been happening with CEO pay. CEO pay over the course of the last 25 years has increased fivefold. If you look on, this is on an inflation adjusted basis, by the way. This is inflation adjusted. Whereas, so this is all year 2000 dollars. Whereas the pay for median workers in the U.S. on an inflation adjusted basis has not increased at all during this period of time. So, now remember, this is the pay for one person, whoever happens to be the CEO, has gone up, as I said, by a little over fivefold over the course of 25. So that could be another reason why, you know, all these people are concerned about this executive compensation. Now, of course, you know, when people are doing well in the marketplace before the Great Recession, you know, everybody's willing to share and share alike. But when the wolf is at your door, and you know, and people's pots are bare, then they get a little bit more concerned when your pot is bare and somebody else's pot is overflowing. And so maybe this is part of what's motivating all of these shareholder resolutions about executive pay. I don't know. So anyway, I would conclude that this, in general, in the wake of the Great Recession, we've seen a tremendous increase in shareholder advocacy. And in particular, we've seen a lot of attention and concern about these issues associated with executive compensation. And I think ultimately we can conclude one thing. The shareholders want to ensure that firms are really being operated in a manner that's going to maximize their financial interest as opposed to the interest of management. And so I think this is a lot of what seems to be motivating this activity and this concern. All right, so I'm done. Questions, concerns, comments? No questions, no concerns, no comments. Yes, sir.
Has the concern for executive pay resulted in a reduction?
Well, it's not a reduction, but it's kind of leveled off there a little bit. Just leveled. It's kind of hovering. It's hovering. It's backed up in it though. It's hovering. Yes, sir.
What is, when the pay is going up,
Yes.
how does that relate to the profits going up?
Well, that's one of the issues, and in fact, there are a number of people who do research in this area, but I personally probably done the most research in this area is a guy out of UCLA named Murphy, and I think one of his concerns is there's been kind of a disconnect between, firm performance and compensation. And there are a number of reasons why there's this disconnect. But again, a good example of this is, an egregious example of this, is like, as I said, is the AIG situation. And clearly, how can you have a firm and a business unit that is essentially wiped out the wealth of all of the shareholders of the firm, but their management is still, through some kind of scheme, through some compensation scheme, is still legally entitled to walk away with $165 million. You essentially wiped out all the wealth of the shareholders of AIG, but through some kind of means, through however this compensation contracts are structured, they're still entitled to. So there's clearly some disconnect between the profits, which would drive shareholder value, and the compensation schemes that are dictating what these executives are getting paid. See what I mean? And that's part of the concern. And a lot of what's driving these resolutions is to try to figure out how to get those things aligned. How do we get executive pay schemes aligned with the things that are driving shareholder value? Yes, ma'am.
What about when management decides to sell their shares short and then drives the price down, and then they buy back in at a much lower rate, and in the meantime, shareholders, of course, have lost a lot of money?
Well, I guess there are sort of two answers to that. The first answer is that the SEC monitors the activity of insiders. And insiders are required to disclose, their purchases and sales of securities in which, they are associated. So it's one of the reasons why we know some of this activity goes on. But two is an issue of enforcement. And the reality is I think the SEC is like a lot of regulatory entities. They pick their battles. They say, well, who is worth our while to fight with? And so if people are not, how can I put it, egregiously enriching themselves in a wanton way, like sort of a criminal way, a Bernie Madoff way, I think they sort of say, well, we got to pick our fights here because we only got so many horses to chase after people. We pick our fights. And so I think that's part of what you see, which is there are some rules against this sort of thing. There is disclosure, but at the same time, you have regulator, the primary regulator is the SEC, but they have limited enforcement resources, and they pick their battles. And, you know, one of the things that, you know, has distressed a lot of people in the wake of the Great Recession and the financial crisis is that you didn't see too many perk walks. You didn't see too many people walk into jail with their hands behind their backs, you know, in handcuffs, you know, because as a U.S. attorney once said to me, it's easy to prosecute people when they walk into a bank with a gun and steal money. As soon as you start talking to people about accounting, it's hard to hold the attention of the average jury. So someone's got to do something really bad for us to go through all the work, and there's got to be a lot of money involved, for us to go through all the work of trying to educate the typical jury enough to convict someone of the kind of larceny that people do with pencil, paper, and a calculator. And that's the reality. So, yes, sir.
So this increase in pay, is this because the boards aren't able to do anything about it? Or is this because, like you said with Jack Welch, most of the boards have a CEO that is on the board that prevents that from happening?
Well, there's a combination of factors, and I think that's a topic for another presentation, but one of it is that sometimes you should have board structures that make it less than likely that people are gonna try to limit executive pay, such as you have a situation where the CEO is the chair of the board. Two, you also have a situation where people tend to like to bring onto their boards people that they know and have had relationships with. So oftentimes people who sit on boards are themselves senior executives at other firms or have been senior executives at other firms. And so they are, how can I put it, empathetic to the financial plight of the CEO.
They're like-minded.
Yes, you know, and so, and then the third thing is what people call the Lake Wobegon effect. There are firms who do quote-unquote compensation studies on how CEOs are paid. And they establish what the median pay is for CEOs, you know, every couple of years. And you pay them a lot of money and they'll tell you what it is. Well, like in Lake Wobegon, where all the women are strong, all the men are good looking, and all the children are above average, most firms tend to think that their CEO is above average. So when they see the median number and it's time for the renegotiation, then the CEO says, well, I'm above average. I should get higher than the median, and that causes this upward creep. Because if everybody's above average every year, then the pay just keeps going up, right? It's the Lake Wobegon effect. As I said, you know, most people don't think their CEO is below average, you know, and so that is part of what explains this creep in executive compensation. Yes, sir.
Well, how do they, how do they get these large compensations when they're fired?
Well, again, you know, people enter into these quote-unquote contracts, and often as part of the contract, there's some sort of severance clauses. But again, the nature and structure of these severance clauses are generally something that can be found out publicly. And again, these compensation experts who go around and track this is a whole industry itself. The people who keep track of executive compensation and charge fees to help you understand this. They help people negotiate, and they say, well, hey, this guy over here at Monsanto got this golden parachute deal, and when you go from here to there, you ought to try to get this, or this guy over here at ConAgra, he got this, you know, severance deal, and you should try to get this. So the point is that you have expert assistance for the CEOs when they're trying to negotiate these arrangements. And of course, they're paying for this assistance, but these people who are providing the assistance, they're surveying the landscape for the best possible arrangements as they advise their clients on how to set up their severance clauses in their compensation contracts. And again, you tend to have this escalation, because if this guy gets this, then the next 3 CEOs who find out that this person got this deal, then they want it. So again, it's kind of escalation, you know. And of course, if you think about it, you have to be a reasonably competent person for someone to want you to be their CEO. And so there's a kind of a courting that's going on. And so it's not the most favorable negotiating environment to sort of say to someone, no, we don't want to give you that. You know, it's like, you know, now, of course, corporations aren't as smart as the NFL. You know, the NFL solved this problem, because, you know, they deal with prima donnas too. But in the NFL, they kind of have a modern day slavery, like, we the only game in town, we're gonna tell you what we're gonna pay you. You know, and if corporate America, if the boards of corporations can figure out how to do that, then they can solve this problem. But they don't have that structural advantage in play. Now, I think I'm gonna stop, because I get that leave-taking look on the part of some people who look like they maybe need to go to another class. So I'm gonna stop and say thank you very much. It was lovely to chat. And if you didn't sign the sheet, make sure you sign your sheet. Where is the sheet?
Okay.